Hello and welcome to Courts Today by Live Law. Let us get to today's top headlines. In the Sambhal Masjid Road, the Supreme Court has halted execution of a municipality notice regarding a well near the Sambhal Mosque. The Kerala High Court has held that BH series registered vehicles are subject to motor vehicle tax as per state law and centre cannot prescribe tax rates. The Supreme Court is set to determine whether advocate on record designated as senior advocate has a duty to notify the client about the same. In the Krishna Janmabhoomi Shahi Idgah dispute, the Supreme Court has expressed a reluctance to interfere with the consolidation of suits by the Allahabad High Court. The Apex Court has refused to review reduction of JEE Advanced attempts but allowed the petitioners who dropped out between 5th November and 18th November 2024 to register. The top court has directed no tree cutting in Mumbai's Aarey Colony without its permission. The Apex Court has dismissed a PIL alleging exchange of currency defaced by Kashmiri separatists at RBI branch, noting that the petitioner suppressed facts. And the Supreme Court has dismissed two PILs challenging deferment of women's reservation in Lok Sabha and state assemblies. I am your host Urvashi Chauhan with your daily roundup of legal updates from across the country. But before we start, let me tell you, Live Law Academy is offering a value-packed opportunity for the aspiring judges. The Judicial Services Examination Preparation course. This comprehensive online course is designed to help you prepare for your judiciary exams. The classes are conducted by expert faculty including retired judges. You would learn from actual case studies and other easy to follow study materials. And all of this at an affordable fee. So if you are gearing up for the judiciary exams, this is a must-check opportunity for you. Enroll today and get 20% scholarship. You can check all details at www.livelawacademy.com. The Supreme Court today stopped execution of a notice issued by the Sambhal Nagar Palika concerning a well near the Sambhal Mosque in Uttar Pradesh. The decision came while the court was hearing a petition filed by the Sambhal Shahi Masjid committee challenging a trial court's order which directed an advocate commissioner to survey the mosque. The survey was a part of a suit alleging that the Mughal-era structure was built over an ancient temple. Senior advocate Hufaiza Ahmadi, representing the mosque committee, highlighted the notice's implications, stating that it referred to the well as Hari Mandir, potentially leading to its use for religious rituals by others. He emphasized that the well was currently used for mosque-related purposes. Advocate Vishnu Shankar Jain, on the other side, representing the plaintiffs, argued that the well was outside the mosque premises and should not be a part of the SLP. Ahmadi countered this, asserting that the well straddled both inside and outside the mosque boundary. The bench led by CJI Sanjeev Khanna and Justice Sanjay Kumar has today issued a notice to the respondents instructing that the notice regarding the well should not be enforced until further orders. The court has requested a status report on the matter within 2 weeks and the case has been posted to 21st February now. In an important ruling, the Kerala High Court has clarified that vehicles with Bharat registration, that is BH series registration number, must pay motor vehicle tax according to the rates set by the state where the registration is sought. This is because motor vehicle taxation falls within the state's jurisdiction and the central government does not have the authority to set tax rates for BH series vehicles. Justice Dinesh Kumar Singh delivered this verdict while addressing a batch of writ petitions from vehicle owners contesting the Kerala Motor Vehicle Department's requirement to pay state taxes for BH registration. As per Section 47 of the Motor Vehicles Act, if you move your vehicle to a different state and plan to keep it there for more than 12 months, you must register it again in that new state. In the year 2021, central government introduced the BH series to allow the seamless transfer of vehicles across states. The BH series registration is available to defense personnel, employees of the central government, state government, central or state public sector undertakings, and private sector companies or organizations which have their offices in 4 or more states or union territories. The BH registration eliminates the need for re-registration because these persons undergo frequent relocations due to transfers. Now, the Central Motor Vehicles 25th Amendment rules, particularly Rule number 51B, outlined the tax rates for BH series vehicles. However, the Kerala High Court has now held that these rates cannot be enforced as the power to levy and set motor vehicle taxes resides with the states under the Constitution. It noted that while the central government can establish taxation principles for vehicles, it cannot prescribe specific tax rates, which remain a state prerogative. The Supreme Supreme Court is set to determine if an advocate on record must inform their client about being designated as a senior advocate, allowing the client to arrange for another lawyer to file a wakalatnama. For your understanding, let me tell you, under the Supreme Court Rules 2013, only an advocate on record can sign and file documents for a client in the Supreme Court. Other lawyers can appear or plead in a case if instructed by the AOR or permitted by the court. A senior advocate, according to the Advocates Act 1961, is a highly experienced lawyer recognized by the Supreme Court or High Court for their expertise. However, a senior advocate cannot file documents, draft legal papers, or take briefs directly from clients. They can only argue cases once an AOR files the necessary documents. So, if an AOR is designated as a senior advocate, the client must hire a new AOR to handle the case filings. A bench of Justices Abhay Asok and Ujjal Bhuya was dealing with an appeal filed by State of Madhya Pradesh against acquittal of a man in a criminal case. During the hearing, the counsel for the state pointed out that the office report recorded the designation of the respondent's AOR as a senior advocate, necessitating issuance of a notice from the court to the respondent to make alternative arrangement. Noting that such instances have become common where the court has to issue notice informing the litigant of the need to engage another AOR, the court today decided that it will pass directions regarding responsibility of an AOR to communicate necessary information to the client. Thus, the court has directed the Registrar Judicial to submit a report to the court detailing any specific rule or practice direction under which alternate arrangement notices are issued by the court to litigants whose AOR has been designated as a senior advocate. In the next update, the Supreme Court today expressed hesitation in intervening with the Allahabad High Court's decision to consolidate multiple legal suits related to Krishna Janmabhoomi Shahi Idgah dispute in Mathura. A bench comprising CJI Sanjeev Khanna and Justice Sanjay Kumar noted that consolidating the cases could benefit both parties involved. However, the bench today did not issue a formal order. It scheduled the matter for 1st April. The Shahi Idgah Mosque Committee had filed a petition challenging the High Court's decision from January last year to combine all 15 suits filed by Hindu groups asserting claims over the mosque. The committee's counsel argued that the suits, being of different natures, could lead to complications if consolidated. Despite this, CJI Sanjeev Khanna remarked that consolidation might not affect the outcome and chose not to interfere at this stage. The Supreme Court is also reviewing other petitions from the Mosque Committee, including challenges to the transfer of suits to the High Court and objections based on Places of Worship Act. The Supreme Court today declined to interfere with the authority's decision to reduce the number of attempts for Joint Entrance Examination Advanced or JEE Advanced from 3 to 2. But the court did provide relief to the students who dropped out of their courses between 5th November and 18th November 2024, allowing them to take the exam. Writ petitions here were filed by aspirants after the Joint Admission Board initially announced on 5th November that students could attempt the JEE Advanced 3 times. But just 13 days later, the decision was reversed, limiting attempts to 2, causing distress among students who had acted on the initial announcement. The Solicitor General today explained that the reduction back to 2 attempts was aimed to ensure students focus on their ongoing studies rather than repeatedly attempting the JEE. The petitioners, on the other hand, argued that they had made irreversible decisions, like dropping out of their engineering courses based on the promise of 3 attempts. The court acknowledged this and permitted those students to register for the exam, citing the principle of promissory estoppel. The court also clarified that it was not questioning the board's policy decision but emphasized the need to address the concerns of affected students. Moving ahead, the Supreme Court today directed that no tree felling permissions within the Aarey Colony area in Mumbai be granted without prior approval from the court. The bench comprising Justices Abhay Oak and Arvind Kumar issued this order in response to ongoing concerns about tree cutting for metro car shed construction. In November 2022, the court had rejected the Maharashtra government's decision to allow a metro car shed in Aarey but permitted Mumbai Metro Rail Corporation Limited to apply for tree cutting permissions. In April 2023, the court had fined MMRCL 10 lakhs for exceeding the allowed tree felling limit by seeking to cut 177 trees when only 84 had been permitted. MMRCL informed the court today that there are no pending proposals for further tree cutting in the area. The court will now hear the matter on 5th March. Stay tuned. In another update, the Apex Court has today dismissed a public interest litigation seeking CBI inquiry into the Jammu regional branch of Reserve Bank of India, where defaced Indian currencies worth 30 crores were allegedly exchanged by a separatist group in the year 2013. The petitioner here filed the present petition in 2019, alleging that Kashmiri separatist group named Kashmir Graffiti defaced and stamped anti-India slogans on Indian currencies and posted them on its social networking sites. Subsequently, the defaced banknotes worth 30 crores were allowed to be exchanged by an RBI branch in Jammu region. According to the plea, the RBI Act and RBI Note Refund Rules of 2009 did not allow the bank to exchange defaced notes. The petitioner had initially sought a response from authorities, but to no avail. As RBI failed to reply to its RTI queries and CBI failed to act upon his representation, the petitioner approached the Supreme Court seeking a CBI probe. During the hearing today, senior advocate Jaideep Gupta for RBI submitted that the petitioner was a dismissed employee of the bank and there was no basis for his statement. The petitioner appearing in person submitted the Times of India, which published on the issue, is a reliable newspaper. In response to his argument that RBI was denying the allegations after 5 years since filing of the PIL, Justice Suryakant pointed out that the petitioner himself had not disclosed all relevant facts in the petition, including that he was a dismissed employee of the bank. After the petitioner conceded that he was a dismissed employee, the bench passed its order refusing to entertain the petition. But the bench of Justices Kant and N.K. Singh clarified that the issues, if required to be adjudicated, will be addressed in an appropriate case. And lastly, the Supreme Court has dismissed 2 PILs related to the Constitution 106th Amendment Act 2023 and a challenge to the delimitation clause. This constitutional amendment for 33% women's reservation in the Lok Sabha was made into a law after the assent of President Draupadi Murmu in September 2023, but it will not be implemented until a delimitation exercise is conducted following the next census. The first petition here, filed by Congress leader Jaya Thakur, argued for immediate implementation of the women's reservation in Lok Sabha, state legislatures and Delhi Assembly. It was argued that once passed with overwhelming support in a special session called for the purpose, the law cannot be withheld. But the bench of Justices Bela M. Trivedi and P.B. Varale dismissed the PIL as infructuous since it was the bill that had been challenged in the court and had already become a law now. The second PIL, filed by the National Federation of India Women, represented by Advocate Prashant Bhushan, also challenged the delay in implementation due to delimitation clause. But the court dismissed this also and suggested that the petitioner approach the High Court to challenge the constitutionality if desired. The court said that there was no violation of the fundamental rights, including Article 14, and therefore did not entertain the petitions under Article 32 jurisdiction. For detailed reading on the cases that I discussed here, you can visit our website at www.livelaw.in. Dear viewers, your support means the world to us. So please do not forget to like, share and subscribe to our channel.